morning, everyone. My name is Philip Argy. I've been an explorer of rules-based systems since about 1970, so probably 40 or more years playing in the space. I'm somewhere between a sole practitioner and a lunatic. If you ask me what I do, I say I do what I like, when I like, for people I like. And how am I able to do that? Well, you then ask me, where's my office? And I say, here. And that's the truth. I mean, this gives me access to whatever I like, including a reminder of what I said I'd talk about today, which I just need to pull up. And I think you do have a copy of some of the things I said I'd talk about. I mostly, actually, because I'm wearing my hat as chairman of the Legal Technology Committee, more than as a practitioner, I wanted to mostly just simply answer lots of your questions. But I did want to start out with one, I suppose, pet topic, and that's to debunk some of the myths, and in particular some of the prognostications I see about the future of the profession in the age of technology. I particularly have in mind a famous father and son who make some predictions which I think are a bit sus. Let me start with a story. In the mid-70s, when I'd first joined Stephen Jakes and Stephen, as it then was, and I got a bit of a reputation as being a technology guru when 99.9% of lawyers were then technology averse. And I wanted to write some legal expert systems because I'd done computer programming and I'd become very familiar with the paradigm of taking problems and solving them in the context of a limited rule set and some constraints about what the available solutions could be. And so I quickly discovered that computer programming, which I'd really taken to, and the law were actually very tight analogues. Indeed, I remember one of the first cases I appeared in, and a judge was asking me to explain how computers worked, and I'm fond of analogies, as most lawyers are, and I said, look, it's simple, Your Honour. The hardware is the court, the operating system are the rules of court, and the application software are the pleadings. And just by analogizing it that way, a judge who knew nothing about technology instantly understood the relationship between hardware, operating system, and application software. And it was a very accurate analogy as well. So I think the ability to put things into other people's language is important. But coming back to these prognostications, when I first put to some of the senior practitioners at Stephen Jakes that I should write legal expert systems based on expertise of theirs, they were quite fearful because they felt threatened. They were the guru of their area of specialty. If I were to capture their expertise in a computer program, they would feel superseded, which indeed is one of the kinds of prognostications we have made. And yet, by the late 70s, I had a large number of people using it, and the best advocates were these senior practitioners whose expertise I'd captured. So let me explain why that is so, and that's really the secret to why the lawyers won't become obsolete. I took a senior M&A partner, and for about 30 major takeover transactions over a period of 6 to 10 months, I sat down and captured what questions he was asking himself, what criteria he was using to determine the answer, and what the answer was. So his mental checklist of how he did a takeover transaction, all the questions he'd asked. Now, by the time I'd finished and written one of these things, he was a bit of a skeptic, and I said, look, I'll prove it to you this way. You're the only one who's going to use this for the time being. I'm not giving this to anybody else. So I'm going to let you use the software I've created based just on your expertise. And here's what we discovered, that the next transaction he did, he used the software and he said, hey, it's asking a question that I'd forgotten to ask. So it's asking questions based on the last 20 transactions he'd done, but what we discovered is that humans have a very poor consistency. Doesn't mean you're a bad lawyer, not negligent or anything like that, but we are very poor at following the same, asking the same questions in the same context all the time. We actually only do what we think of at the time, and we aren't very consistent. And what we actually discovered was it was applying his expertise more consistently and more reliably than he was. Because it would always ask a question when it was relevant, even when he'd forgotten to ask it, and it wouldn't bother asking an irrelevant question if he asked it not having thought it through properly. So the quality assurance was fantastic. So the next thing we did was allow his associate to use it. And then all he wanted to see was, show me the answers that the associate gave to the questions the system asked, because once I see the answers, and I'm confident that he gave the right answers, I know the outcome will be trustworthy because it's what I would have done. So what do you learn from that? What you learn from that is that if it's done properly, these are tools that lawyers will use. And in the same way that you might now use precedents, you will be able to have precedents of expertise. And you get good precedents and bad precedents. But they're just more tools. Technology is a great enabler of the problem-solving skills of lawyers. The actual core skill of a lawyer is solving a problem. And a lot of what lawyers do is paper shuffling to get to the point of solving the problem. It's what rules apply to this problem, what are the facts. Now let me actually take my lawyer skills and apply that and come up with the optimal solution for the client.
Can I ask you, where do you see that heading? How's that going to impact on lawyers looking towards the future?
I think it means that lawyers who are good at capturing their work product will be in a better position. And one of the things I wanted to lead into was the process of costing legal services, because I use the analogy of a builder. If you go to a builder and say, I want to build a 20-storey building, you don't build that by time costing. You don't get a quote. How do you get a quote on a 20-storey building? And you normally say, well, I want this quality of fixtures and it's going to be so many square metres. And what the builder does is pull out a bill of materials based on their past expertise. They say, we know for a 20 square metre building of this height and using concrete and steel, in the past we know it requires 27 tonnes of this grade steel and 47 cubic metres of this concrete and whatever it might be. They didn't just dream it up, that's their precedent, and they can scale that accordingly. And so one of the other things we did as an experiment in these same transactions was to capture who worked on it, and we discovered it took, say, 320 hours of partner time, 700 hours of a senior associate time, and you could actually build a bill of materials for a matter. And so you could actually say to a client who said, I don't know, what would it cost to do a prospectus? And you could say, well, it would cost $53,800 for a standard prospectus. And then you can have extras, same as builders do, for anything quirky around the edges. The beauty of that is you're extracting first of all, you're giving the client certainty. Secondly, you're giving yourself a comfort level. Lawyers are poor at estimating. They'll lose money more often than not because they're scared of being undercut by a competitor. They don't know how to get the value for what they do. If you can say to a client, and indeed in many cases the client is an in-house lawyer somewhere, they would much rather know $53,800 than comparing someone whose time costing is $600 an hour with someone who's quoting them $500 an hour. Governments always go for the $500 an hour, even if that person would take 4 times longer. There are very poor acquirer of legal services. I mean, I've been on a panel at the moment for the New South Wales government, and the interview panel we went to said categorically, it's just rates. The decision will be based on your rates. I said, well, that's fine, I'm not budging on my rate. Let's see how the evaluation comes out.
You think, I think you're saying that technology is used as an enabler.
Absolutely, it's an enabler, it's a tool, particularly for quality assurance. I mean, law cover should be delighting in what technology will be able to do. It will be able to prevent people accidentally making mistakes. It will improve the reliability of the legal processes, and it will let the lawyers focus on their skills, solving problems.
How do you see it evolving? Where's it going to end up, if it'll ever end up?
It's a continual process of evolution. It's a bit like saying, where will mankind end up? You just keep incrementally getting better at what you do. The tool sets improve. The humdrum bits of legal research will be improved by the use of tools, but again, humans won't be replaced. I mean, my favourite test of all this fantastic new super artificial intelligence is to say to it, give me all the cases that don't follow Donahue and Stevenson. And they can't, because they use crude methodology right at the base level, and that is to search for Donahue and Stevenson. And if it appears in a case, they think, oh, well, you don't want that one. They don't analyse the text and say the judge says, I'm distinguishing this from Donahue and Stevenson. So it's the very case you want, and it's the one it won't retrieve.
But it's not beyond the realms of imagination and invention that some time down the track they will be able to provide the answer.
It'll get better. But again, you know, it's the fact that here today, something as simple as that, you still need humans for, tells me it's still a while away. There's something humans can do that others can't.
Do you see the role of lawyers changing in the future?
Not if you agree with me that at the core of lawyering is problem-solving skills. You will get maybe harder problems you'll be able to solve with some lower cost people, and the higher cost people will do harder problems. There's only so many billable hours in a day, so time costing can't work. You've got to move to value billing, and you will do that when the client is comfortable that they're paying a fair price for you to solve a problem. It's really an educational process, but we found that clients actually prefer the certainty and the articulation of what you will get for that price. So you can describe, you know, I'll give you a 50-page prospectus and it'll have all the standard statutory material in it, and it'll have this, that and the other, and if you want something extra, here's how I'll charge for the extras. But you can do that, and people actually prefer that.
I might just open up to the rest of the panel for questions.
Yeah, Philip, you said in the 1970s that 99.9% of the profession was technology averse. What number would you put on the profession today, and does that make you optimistic or not?
There's certainly a much lower percentage who are technology averse. That's true. I mean, I suppose anyone under about, I don't know, pick a number, 30, would be very comfortable with technology, but not necessarily conversant with its deployment in their legal practice. So I think there's a difference between being technology averse and being technology literate. In fact, one of the issues I've identified is even the people who are now technology comfortable are actually the biggest danger, because we've got the examples I've cited of lawyers who think you can witness a document by Skype, by seeing your client on the screen sign the document, and they say, post it back to me and I'll sign as witness because I saw you sign it. It's utterly absurd. I mean, but because their thinking process is, this is like being there. And so they're so comfortable with technology, they haven't appreciated the fundamental problem with what they've just done. And so one of the things the Legal Technology Committee is thinking about is actually recommending to Council that we actually have some mandatory CLE in some of these issues because it's actually getting dangerous. So there's a downside of being technology comfortable.
Philip, could I ask about this? You'd be aware, I'm sure, that there are nearly 30,000 solicitors here in New South Wales, solicitors not including barristers, and of those 60% are in the private profession, and of those 40%, give or take, are sole practitioners. The range of solicitor members of the Law Society is huge. A lot of those will have little or no great experience in the things that you're talking about. How do we help them get started? How does that happen? Leave aside the experts for the moment, but the people who are either nervous of this, are opposed to it, or just don't know how to handle it, where do we go?
We have to put in a plug for the small practice portal. There's a lot of terrific material there that is exactly orientated to answering that question, and our committee has put a lot of material on that portal as well, but it's specifically for people setting up a sole practice on what to equip yourself with, what are the pros and cons, how do you manage the risk, which is always a significant issue. So there's a wealth of material there which I would refer you to. I'm not sidestepping the question, but it's designed for that, to answer that very question. It's a terrific resource. I wish more people would use it.